two simple submissions. One is there was a liquidated pecuniary claim, and two is that by saying they were undisputed, there was an acknowledgement of the claim, and you should apply a generous construction to acknowledgement of the claim, even though that's on the face of it is a matter of Mr. Justice Cockerill, needs to be an instance of liability. One should remember that the main purpose of section 29(5) was to save the defendants from being harassed by stale claims, not entirely the sort of defendant as Sahara, where the claims are not stale and were being actively negotiated. And the only remaining issue, if everything else is decided against me, was a single point of construction of clauses 8 and 36, which I said there wasn't. So I say that on the facts of this case, there was an acknowledgement of the claim from a liquidated sum, and it shouldn't be time barred. And it's a simple point. This is your lordship's further. Mr. Dew and Mr. Rich, Mr. Dew's submissions do not entirely, they overlap with the limitation point, but they aren't entirely dependent upon it. And Mr. Rich's submissions on clause 8 as a liquidated damages are, I think, entirely dependent upon my learned friend's sayings. So, unless I can assist you further, I am going to save you from having to listen to me further.
Thank you.
Thank you very much.
Mr. Dew.
My Lords, my submissions address the third ground of appeal, and they concern Sahara's claim for indemnity under clause 26 of the contract and the limitation period for such indemnity clauses. In terms of structure, I'm going to split my submissions into two parts. I'm first going to deal with the question of whether these sums, the sums in question being interest and charges, whether they are recoverable at all under clause 26. And in the second half of my submissions, I will deal with the question of the applicable limitation period. But before I do so, can I first of all set out the consequences if the court is with me on this ground of appeal. The consequences would be that Sahara is entitled to recover interest and penal charges. When I say interest, I mean both types, incremental and excess interest, which accrued after 21st of April 2015. That is 6 years before the claim form was issued in this case. And in terms of financial impact, can I just first of all set out Sahara's original claim at trial? There were 3 claims. Firstly, incremental interest, just over $20 million US. Secondly, excess interest and penal charges, which was just over $24 million US. And thirdly, FX differentials, which were just over $56 million US.
Yes.
If Sahara succeeds on this ground 3 of appeal, our position is that Sahara would be entitled to recover most of the incremental interest. I say most, not all of it. And Sahara would also be entitled to recover most, but not all, of the excess interest and penal charges. So in terms of incremental interest, our calculations are that about 18 million would be recoverable, and in terms of excess interest and penal charges, we say that just over 16 million would be recoverable. Those were our calculations at trial, which were presented to the judge alongside the relevant evidence. Sahara did not address this material, and the judge did not make any findings in that respect, because she did not need to make any findings, given her findings in respect of the proper construction of clause 26. So if quantum cannot be agreed, it would have to be remitted, but nevertheless, there's a very substantial sum of money at stake here. We accept that FX differentials are dismissed on 2 grounds which are not applicable to the other 2 heads of loss, and there's no appeal in respect of FX differentials. So with those introductory comments, my lords, can I then turn to the first part of my submissions concerning the proper construction of clause 26. And can I make these submissions by reference to clause 26 itself? The court can find this clause set out in the core bundle, tab 13, page 194. And can I just briefly explain the structure of clause 26? So clause 26 is titled Events of Default / Termination Clause. We then see that events of default, they are defined, and you can see that there is a list of events of default lettered A, B, C, D, E, F, G, and H. And following from those events of default, one can see that there is then a list of remedies set out, and those are lettered A, B, C, and D. Following those list of remedies, one can then see a number of further paragraphs. The first further paragraph, it provides explanation as to how remedy A works, because the paragraph refers to an early termination date, and that is a reference to the remedy set out in paragraph A. And then the second paragraph is also concerned with how remedy A works, because again there is a reference to an early termination date. And then the third paragraph deals with remedy B, because it refers to suspension of performance. That is a reference to paragraph B. And then we come to the penultimate paragraph, that's the paragraph which we're concerned with in this case. That sets out the indemnity. And then the final paragraph states that the remedies set out in clause 26, they are not exhaustive or exclusive in any way. My lords, we say that the analysis of the penultimate paragraph of clause 26, it's straightforward. It states that the buyer shall indemnify and hold the seller harmless from all losses, damages, costs and expenses, including legal fees that the seller would not have incurred but for the event of default, and or be exercised by the seller of any of its remedies here under. So in our submission, in this case, there was non-payment. That is an event of default, specifically it falls within event of default A. And in those circumstances, Sahara is entitled to an indemnity for losses which would not have incurred but for that event of default. And those losses in question being the interest and penal charges which I've outlined. And we say that the indemnity here, it does not depend on Sahara exercising any of the lettered remedies A, B, C, or D. And that is made absolutely clear by the words and or. Provided that losses have been incurred which would not have been incurred but for the event of default, that is sufficient to trigger the indemnity and gives rise to an entitlement to payment. And we say that this analysis, it is supported by the context of clause 26 and the contract. These were open account transactions. Sahara was in effect extending very substantial amounts of unsecured credit to Sahara, the figures in question being over 50 million euros per cargo. And we say it is unsurprising in those circumstances that there would be extensive indemnity provisions contained in the contract. Now, my lords, the analysis I've set out, we say it's straightforward. It was also uncontroversial on the pleadings. And if I can make good that point, my lords.
Just before you do, can I just understand that what you say that the scope of this indemnity is? First of all, am I right in understanding you say that the first half of it arises where there is an event of default, but there's no need for it to be called as an event of default by notification being given, which is the precursor for the various remedies?
That's right, my lord.
Secondly, do you say that it is an indemnity which applies only, sorry, let me put that another way. Are you saying that it is an indemnity which responds, provided only that the but-for test of causation is established, so that it doesn't involve the Eurus kind of factors of remoteness and principles that apply to contractual damages?
No, we accept on this appeal that clause 26 is subject to the limitations of clause 18, and there being various remoteness restrictions set out in clause 18.
That was going to be my third point, but yes, all right. Subject to clause 18, is it as a matter of construction of what's meant by indemnify in this case, also qualified in the way that Mr Justice Thornton thought in the indemnity in that case was qualified, namely that it only gives a right to damages insofar as they would be recoverable for breach of contract?
The losses in question would have to be foreseeable losses. They do not cover unforeseen losses. The point doesn't arise in the facts of this case because, as Mrs Justice Cockerill found, the interest and charges, they were not unforeseeable losses.
And that you concede is a matter of what's meant by shall indemnify, rather than the result of the application of clause 18, which has a different test.
Yes.
Thank you. And are there, sorry, just while we're, are there any other clauses to which, other than clause 18, to which you accept clause 26 is subject?
No, my lord.
Thank you.
My lord, the submission I was making was that on the pleadings, the analysis I set out just now, it was largely uncontroversial.
Sorry, just before we do that then, so we might have to have the contract out for this rather than the clauses,
Of course.
which I got starting at page 25. So if we look, for example, on page 26, the delivery clause, 3 paragraphs down, the provision says if the buyer fails to lift the contract volume within the indicative lay days, then the buyer shall reimburse the seller for any or proven direct costs, expenses and damages. Does the indemnity overrule that?
No.
So it's also subject to that.
It's subject also to that clause, but of course that clause didn't arise in this case.
Thank you.
But it could do. I mean, it may not have arisen in this case, but we're looking to see what the contract means.
Yes, ma'am.
So you have to sort of sit there at the time of contract and look forward in different hypotheses that might occur to the buyer.
So without going through all the contractual terms, maybe one or two others that I need to put to you, but is it your case that essentially clause 26 indemnity is subject to any other clause which narrows the scope of recoverable losses for particular kinds of breach.
In principle, yes, we accept that as a proposition.
Thank you. Thank you. You were going to think to take us to the pleadings.
Yes, my lord.
Just actually before we all put this away, if we've got it out, do we get anything from the layout at page 35? It's not a layout, it is just a I think it is mentioned somewhere at least. I can't remember exactly where it's mentioned.
Yes, so my learned friend makes the point that there is various indentation in the paragraphs which follow from remedies A, B, C, and D. In my respectful submission, this was not a point which the learned judge focused on, and in my submission, there is nothing to be gained from the indentation of these paragraphs. Now, there is a separate point, my lord, which is the structure or the order in which these paragraphs were set out. And I'll address the court now on that question. We say that the analysis which we have put forward is entirely consistent with the way in which the clause has been laid out. So the proposition we are putting forward to the court is that this is an indemnity which responds to either an event of default or the exercise of a remedy which has been set out in clause 26, these being additional remedies to what remedies would be available at common law. Now, in order for such a clause to make sense, one would first need to set out what the events of default are, otherwise one has no idea how the clause operates. And secondly, one would need to set out what the remedies are, what the specific remedies A, B, C, and D are. Otherwise, one has no idea how the indemnity works. So, in those circumstances, it makes perfectly good sense to have a clause which is structured, where the events of default are set out, followed by the remedies, including qualifications or explanations as to how the remedies work, followed by an indemnity provision, which provides that losses which are the result of either an event of default or the exercise of one of those remedies, they are recoverable under the indemnity.
So, in your submission, the clause comes in three parts. Part one identifies events of default. Part two identifies remedies for that can be exercised in the event of an event of default. And then part three are the last two paragraphs, which provide for an indemnity in either or both of those events, and that indemnity is doesn't exclude other remedies.
Yes, so the final paragraph is general application, and yes, it has the effect that your lordship has identified.
So the indentation point is that if for better or worse, is that the third part isn't treated in the same way as having its own separate indentation in the way the first and second parts are. If we look at it, the events of default have their own indentation, the remedies have their own indentation, or lack of indentation, perhaps is a better way of putting it. But what you say is part three doesn't.
Yes, well, if one looks at the final paragraph, that is clearly of general application. It simply says that, and I paraphrase here, that the provisions in this clause, they do not exclude any other remedies or rights which would otherwise arise, and there's no need for an indentation there.
So that's so actually my taxonomy should really have been 4 parts rather than 3 parts.
Yes.
Yeah. All right, thank you.
So I am going to take the court then to pleadings, and can I just show the court how these points are put in the pleadings? Firstly, the defence, which can be found in the core bundle behind tab 12 on page 184.
Give me the page again. Sorry.
It's page 184 of the core bundle.
Cool.
And this is Sonara's position on clauses 26 and 18. And the only point which was taken in respect of clause 26 when the pleading was prepared is that clause 26 is subject to the limitations which are set out in clause 18. And of course, Sonara also pleaded that the losses which Sahara was seeking to recover, they are excluded by clause 18, a point which Sonara lost on that trial and for which there is no appeal.
It was a general denial, and then without prejudice to that, there's this particular one.
It's not a pleading point I'm taking, my lord. The point I'm taking is simply that the argument which Sonara has identified, it was a late point which was run at trial, but it did not occur to the pleaders when this pleading was prepared to run this particular point. And the submission I'm making is that the construction which Sonara is putting forward is simply counterintuitive. As I say, I'm not taking a pleading point, I'm not suggesting that the argument in question is a point of construction. It could have been run at trial and it can be run on this appeal.
Right, thank you.
My lords, can I then address how the judge analysed this particular clause? The judge's conclusion, in summary, was that the indemnity only applies to losses resulting from the exercise of remedies A to D in clause 26. And this conclusion can be found in paragraph 190 of the judgment. It can be found in the core bundle on page 127. We say that the judge has failed to give effect to the natural meaning of the words used in clause 26. The words used are and or, which means that the indemnity is available even if the remedies under clause 26 are not exercised. The judge sets out her reasoning in paragraph 190, but simply ignores the critical words and or. And indeed, if the judge is right, then the clause in this particular case, it could have simply said that the buyer shall indemnify for losses that the seller would not have incurred but for the exercise of, by the seller, of any of its remedies hereunder. And the words, the event of default and or would simply be redundant. My lords, the concern which the judge had appears to be that the natural words of clause 26, they appear to identify a very wide range of events of default and also provide for a generous indemnity. And it is implicit in her reasoning that clause 26 is simply too good to be true if given effect to its natural wording. And therefore the judge engaged in a process of reading down clause 26. Now, there is some force to the judge's conclusion that clause 26 covers a wide range of events of default. If I could show the court clause 26 again, I think we should look at the original in the supplemental bundle. events of default are indeed widely drafted. They include all breaches of the specific contract in question. They cover breaches of other contracts. Indeed, they also cover the circumstance where Sahara has good reason to doubt the continuing ability of or willingness of the buyer to perform its obligations hereunder. That's event of default F. And there are also references to insolvency in paragraphs E and G. And the judge also identified that there would be a wide range of remedies, including the termination or suspension of performance or the like, or a discretion to treat these events of default as repudiatory breaches. Now, our submission is that insofar as the court is concerned about the width of this particular indemnity clause, there are some parts of this clause which are more draconian than others. We say that the indemnity which we are seeking to rely upon ought to be uncontroversial and is not draconian in any way whatsoever. A breach of contract will cause loss, and it is usual to have a monetary remedy or an indemnity in response to a breach of contract. Insofar as there is good reason to doubt the continuing ability or willingness of Sahara to perform, that actually does not cause any loss to Sahara unless it further results in an actual breach of contract by Sahara. And similarly, where there is an insolvency event or where there are concerns about the financial standing of Sahara, that would not of itself cause any loss unless it results in an actual breach of contract.
It might do if the remedy is exercised.
Precisely, my lord. So the concern here is actually concerned with the remedy of termination or suspension. That is what is potentially draconian about this particular clause, is that there are a wide range of events of default, and on the face of this clause at least, Sahara is entitled to terminate in all of those circumstances. So insofar as the court is concerned about the width of this particular clause, what the court ought to be addressing is the right of termination. Now, there may be interpretive techniques which can be used to narrow the scope of the remedies set out in A, B, C, and D. For example, it might be possible for the right of termination to be construed so that there is an implicit requirement that it is not exercised irrationally or capriciously. But the point we make is that this is not a case where Sahara has sought to exercise the right to terminate. To the contrary, we performed the contract and we never sought to terminate the contract. This is not a case where the court ought to be concerned about the potential width of the indemnity that we're seeking. We are in effect seeking indemnity to recover the losses which have resulted as a result of a breach of contract. That ought to be an uncontroversial attempt to rely upon an indemnity clause.
What are you saying, that we have to interpret the contract bearing in mind what has actually happened in this case?
No, my lord. What I'm saying is that one needs, if one is, so there are two approaches that the court could take. One is to simply say that these are major commercial entities, they have negotiated a contract, the clause says what it says, and insofar as it's a bad bargain, so be it. That's one approach. The second approach is to say that, well, this clause, if given its natural meaning, it is too draconian. Well, if that's what the court is going to do, then in my respectful submission, the court should identify what is particularly draconian about this clause. And it's not the indemnity for damages or the indemnity for loss which is draconian, but the right to terminate. Whereas the learned judge, in our respectful submission, her approach was the wrong way round, because the judge concluded that the right to an indemnity to loss, that needs to be read down, even though there is, in our respectful submission, nothing draconian or controversial about an indemnity responding to a breach of contract. Whereas the judge said nothing whatsoever, or did not seek to read down the remedy of termination, which is the real concern, if the court has one, regarding the draconian consequences of this clause. And we say, with respect, that that approach was incorrect. Finally, with respect to the authorities cited by Sahara, I'm not going to look at them. The judge correctly said that the authorities, they do not assist Sahara. We of course accept the proposition that the scope of an indemnity clause, that is a question of construction, but the cases cited by Sahara have no further relevance. They are of different wordings arising in a different context, and the court would not be assisted by me going through those cases. So that's what I want to say about whether interest and charges are recoverable in principle in clause 26. And I then deal with the question of the limitation period. I make two propositions. Firstly, on a proper construction of clause 26, the limitation period starts on the date or dates, there might be more than one date, that the loss is incurred. And secondly, for every day of non-payment, there is a new loss in the form of additional interest and, on occasion, further bank charges incurred by Sahara to its banks. But before I develop those points, can I just make one preliminary remark?
Sorry, can I just be clear? But you're not saying that for every day there is a new and fresh breach of clause 26 in failing to indemnify in relation to a loss which has accrued before that time.
Yes.
You are saying that, or you're not saying that?
I'm not saying that. Your Lordship is correct. So just to be absolutely clear here, we say that losses were incurred in 2013, 2014 in the form of interest, potentially charges. Those were incurred in 2013, 2014. We cannot recover them.
Yes. Thank you.
So as I said earlier, the limitation period starts on the date or dates that the loss is incurred. As I said, this is a question. Well, Sahara's position, which we agree with, is that this is a question of construction. They cite the Caroline P and cite Cape distribution to that effect. We agree with the general proposition that this is a question of construction. The point we would make in this case is that the relevant question is simply when the loss is incurred. And clause 26 specifically uses the word incurred.
But you couldn't issue a claim form for loss that has occurred.
Precisely, my lord. Precisely. And not under
these claims for a declaration for an indemnity in relation to future liabilities. The court makes orders that someone is entitled to be indemnified against losses, if any, subsequently recovered.
Yes. But the question here is, to use a hypothetical, there was a default of payment in 2013, 2014. So the question is, if Sahara issued a claim form in late 2014 and sought an indemnity under clause 26 for losses incurred, would Sahara be entitled to recover for losses in the form of interest and penal charges to be incurred in 2015, 16, 17, 18 and 19? And our submission is that Sahara would not be entitled to do so. Those losses have not been incurred. They are future losses.
But the indemnity is to hold harmless from suffering loss which wouldn't otherwise have been incurred. So
Yes.
would you not be in a position in 2013 to say, here's your late payment, we're going to, or we're likely to suffer a series of losses. Please can we have a declaration that we are entitled to be indemnified in respect of all charges that the bank makes on us in relation to incremental interest?
We would, my lord, but what we would not be entitled to is a monetary remedy that is immediately enforceable in 2014, because the losses in question have not been suffered yet.
Yes.
And clause 26, insofar as one is seeking a monetary remedy, and that's what clause 26's purpose really is, one would not be entitled to a monetary remedy until the losses have been incurred.
Major extension of limitation. If you were barred by limitation from a claim that you could have sought a declaration in relation to at an earlier stage, it would mean you'd have to look at when you could have sought a declaration.
Yes.
And that would have very wide-reaching implications for limitation.
Indeed. And also, the analysis is when did the relevant cause of action accrue? And the cause of action accrues on our analysis when the loss has been incurred.
We're talking about which section? No, we're talking about section 5 of the limitation.
Yeah. Yes.
I don't think that's necessarily related to declaration.
No, it's concerned with cause of actions in relation to contractual claims.
Well, the declaration would be, yes, well,
my lords, the next part of our analysis is simply the proposition that Sahara incurs a new loss or liability for every passing day that the principal sum has not been paid. And we say that is simply a reflection of the nature of interest. Interest is a payment for the time value of money. For interest to accrue, time must have passed. For every day of non-payment, more interest accrues, and it stops accruing on the date that principal is finally paid. So for every passing day, additional interest accrues, and that additional interest is a new loss for which there is a new cause of action. And the same analysis applies in respect of the bank charges. And we say that the analysis I put forward, that interest accrues from time to time, that is reflected.
Sorry, when you say the same analysis applies to the bank charges?
Yes, my lord. Yes, I mean the penalty charge.
Because they're calculated on a time basis, are they?
No,
Is that what-
the penalty charges, they were charged from time to time from 2013 to 2019. So every few months, the bank would levy a charge, generally calculated as a percentage figure on the outstanding balance, simply by reason of the fact that there has been late payment by Sahara to the bank. Now those charges, they were levied from time to time, and so the loss was incurred from time to time as well.
In relation to them, the loss was incurred when the charges were made,
Yes.
not by reference to the period
Yes, that's right.
that the charges related to.
Yes, my lord.
So that when you say the same applies to the bank charges, slightly different from your interest point,
I apologise. I wasn't quite.
which is a loss being incurred, you say, day by day.
Yes, but the point I want to make is that these are losses which are incurred across time, from time to time. These are not losses which are incurred once and for all on the date that payment was late on. Now,
So is there a difference in the, does it follow from the answers you just given that there is a difference in the, we haven't looked at them, between the interest clause and the penalty charges clause in terms of how they accrue? One accrues from day to day and the other one, so I'm not following the point you just made.
we say that interest accrues from day to day. That is reflected in the very nature of interest, but it's also reflected in, for example, clause 8, which divides the percentage, the interest rate figure, by reference to the number of days which has passed since the bill of lading was issued.
But we're looking at the interest that you're being charged by the banks,
Yes,
aren't we? And I can understand you saying even if they only send you a claim or a notice monthly or 3 monthly,
yes,
you're saying you are incurring a loss because you're incurring a liability day by day by reference to the time value of money. So at X% per annum, if it's charged on a DM basis, you're incurring a separate liability each day that passes.
that's my word.
Whereas, which is why I asked you what you meant when you said the bank charges, the penalty charges are the same. It's not quite the same. You're saying in relation to the penalty charges, the liability to the banks is only incurred and the loss suffered when the banks impose the penalty.
Yes,
Is that right?
Yes, my lord.
Slightly odd, because normally penalty charges are they're a separate. I mean, do we have these clauses somewhere? Presumably not.
The sums which were levied on Sahara, no, unfortunately.
It's not just a sort of penalty rate of interest there, it's a different
No,
structure of charging.
It's a one-off charge. The figure, as I recall, was either 0.5% or 1% or 1.5% levied on the outstanding balance, and it was seen as a one-off charge.
Quarter per month.
The pattern was not entirely consistent. Occasionally they were once every few months. But all I can say is that they were incurred from time to time. They were not. Those, as the judgment says, there was a final settlement between Sahara and its banks later on. So they were incurred, they were charged, and there was a final figure made, as I recall, around that 2019.
Insofar as it's going to matter for quantum if we get there, but for penalty charges, it's got to be the penalty imposed, i.e. actually charged by the bank
Yes.
after whatever the date is in 2015, but 6 years before you started. For interest, there might conceivably arise something that straddles the date where the interest is incurred
Yes.
on a day-by-day basis before that, but is only levied by way of a bank demand after that. Is that the right way of looking at it?
Yes, that's correct.
So if it was settled, there may be an issue as to how much of the settlement is attributable to the statute barred charges.
That's right, my lord. And so the case which we put forward to the learned judge is that a settlement involved a discount on the sum which was levied by the banks.
So you pro-rated.
We pro-rated it. There were no findings on any of these points of detail, my lord.
You say all that has to be remitted.
Yes, this court doesn't have material to make findings in that respect.
Thank you.
And yes, and Mr. Young points out that so in respect of the penalty charges or default interest, there was a claim by Standard Bank against Sonara, which Sonara sought to recover against Sahara as part of its counterclaim, and that is in paragraph 74 of the
judgment.
defence and counterclaim. These were all dismissed, these claims, but I certainly wouldn't want the court to give the impression, for example, that these were unusual claims, these penalty charges. Can I then address 2 points which are made by Sonara against us? Firstly, Sonara says that the losses in question, they were a continuing loss, and this point is made by my learned friend in paragraph 51 of his skeleton argument. We're not entirely sure what my learned friend means by continuing. Insofar as my learned friend is suggesting that once interest has been incurred in 2013 or 2014, that loss still exists in 2019 because we were not indemnified by Sahara. It is correct, and as I had said earlier, that we do not seek to recover the losses which were incurred in 2013 or 2014. Now, if my learned friend is saying that but continuing means that the interest continues to grow over time, that is correct. And we are saying that the interest which grew after 21st of April 2015, that is recoverable. Sahara also makes the point that the loss before April 2015 is no different, or is of the same type of loss as after 2015. And that is, in our respectful submission, simply a so what point. The losses are nonetheless divisible, and the court can quite easily identify those losses which have been incurred after April 2015 versus before 2015, even though all interest is simply money, is of the same type of loss. Can I then make one final submission, which is that if my learned friend is right in saying that it is artificial or impermissible somehow to say that a new loss or liability is incurred every day, that's essentially his complaint, we say that the result should nevertheless be in Sahara's favour, because on my learned friend's analysis, all of the loss, all of the liability must have been incurred on a single day, if my learned friend objects to us salami slicing the losses day by day. Now, if that is right, then we say the best candidate for the day on which the loss was incurred is actually the day on which the loss was finally ascertained. And that, in our respectful submission, would have been in 2019, when the bank charges, bank interest was finally settled between Sahara and its bank. Of course, that is not our case. That is simply a rebuttal to the analysis which has been put forward by Sahara.
Did you say that the clause envisages that there might be different losses, damages, costs and expenses?
Yes.
So one's not looking at an exercise in trying to identify a single moment at which at which a certain thing, which is the whole of what comes within the clause,
yes, my lord,
is identified as ascertained.
Yes, my lord. That's our submission. And we say that the mistakes of the learned judge were that she appeared to have conflated the event of default, which actually triggers the indemnity clause, as opposed to the loss or losses, which are the result of the event of default. There can be an event of default leading to losses, but they can arise at different points in time. The event of default, or events in this case, they occurred in 2013 and 2014, when there was late payment by Sahara. Losses occurred across 2013 to 2019. My lords, those are the submissions I want to make on limitation, unless I can insist, of course, on
Can I just take you back to page 35 of the supplemental, just the clause 26. I think one of your submissions was in relation to the last clause that starts the provisions of this clause. And I think you said that's of general application, if I remember correctly.
Yes, ma'am.
In fact, it talks about the provision of this clause and the seller's rights hereunder shall be without prejudice to, in addition to, shall no way limit or exclude any. And then it sets out right of termination, set up, combination of counsel lien or other right to which the seller. I mean, they're all remedies, aren't they?
well, apart from other rights.
Well, I mean, but they are. Okay, well, if we are looking at them, it's a right of termination, right of set off, right to combine accounts, a lien. I mean, those are sort of. Those are of the type of species of remedy. I mean, rights which you can exercise by way of self-help or remedy.
The individually identified ones are, yes, I would, but of course, it does say other right to which the seller is at any time otherwise entitled.
Yes, but okay, I think you're probably urging us then to look separately at the clause at the end, which I seem to remember wasn't what was going on before lunchtime. I mean, I thought the point was that you look at the clause as a whole, don't you?
Yes.
You don't say, are we talking about similar rights? Anyway, you say it's not simply limited to something which looks like a remedy. It's just entirely those extra words or other rights. It's entirely.
Yes, and they cover, for example, your common law right of damages. That would be a right which the seller is entitled to, whether by agreement, operation of law, contract, or otherwise.
You don't read that. You say you don't read those words down by the company they keep in the clause.
It says all other rights to. It's very widely drafted, and there's no need to constrain that clause in the way that you would described.
And in any event, it's even if it's a category including other right of essentially remedies other than damages, they're remedies to which the seller may otherwise be entitled, not just under this agreement, but by operation of law, contract, or otherwise, so that on any view it's not confined to remedies hereunder.
Yes.
The same way as the second part of laws we're considering is. Thank you. And Mr. Rich, you're responding to a respondent's notice.
I am.
Strictly speaking, entitled to wait and respond. I think strictly speaking, Mr. Hussain would then be entitled to have a reply on that. But if you're both content for you to make your submissions now, then we're equally content.
I'm certainly content to do so.
Are you content with that, Mr. Hussain?
Of course, Malu. I'm in your hands.
I'll be as brief as I can. The respondent's notice then concerns clause 8 of the relevant contracts, i.e. amendments numbers 3 and 5. The relevant provisions to your note are at tab 4, page 38, and tab 6, page 43 of the supplementary bundle. There's a very minor difference in wording in the first paragraph, but nothing turns on it. If we look at the former, so that's tab 4, page 38 of the supplementary bundle.
And we're looking at it in the amendment just because we're up to the 150 days, which was actually applied to all the cargoes we're concerned with.
Exactly. And if I could ask the court to read clause 8. The key paragraphs are the 3 after payment in euro in bold. The court would have noted that the obligation to pay interest on the principal sum arises before the delay in payment is such as to breach the contract. My lords, the respondent says that clause 8 liquidates all damages flowing from a failure to make payment. The judge rejected that submission at paragraphs 149 to 164 of the judgment. That's at tab 9, pages 119 to 123. If the respondent were right in its contention, and both we and the judge were wrong, the consequence would be to nullify the effects of success by us on grounds 2 or 3 of this appeal, because any damages thereby recoverable would be liquidated, and that liquidated sum would already have been paid. Our position is that clause 8 does not liquidate any damages flowing from failure by Sahara to make payment. It instead merely provides what is in effect a minimum sum payable, with it remaining open to Sahara to show its actual losses are greater, subject to the normal rules on causation and remoteness. I make 4 points in support of that. First, it is of course possible to draft a clause that liquidates all damages flowing from a failure to do something on time, whether that's pay or complete work. Second, whether a given clause has that effect is a matter of construction of the clause in question. An example of a clause which could be so construed is to be found in Temrock and Errol, a case relied upon by the respondent. It's worth looking at that clause. The report begins at tab 6, page 73 of the authorities bundle. If we turn to the second page of the report, page 74, we can see from the very first line on the page that we're concerned with the JCT standard form building contract. And the clause in question is clause 24. It's set out about halfway down the page. If I could ask the court just to read from clause 24, damages for non-completion, to the end of the quotation marks as a debt. The question before the court in that case was whether, if the rate stated in the appendix referenced in 24.2.1 was nil, there could be any recovery. There could not, the court found, because the clause liquidated the damages. I draw your attention in this regard to 2 key features of the clause. Firstly, it's headed damages for non-completion. Secondly, it refers to payment of a sum calculated at the rate stated in the appendix as liquidated and ascertained damages for the period between the completion date and the date of practical completion. And plainly that's a far cry from clause 8. My third point, this follows from the clause that we've just looked at, is that if a clause is to have the effect of liquidating damages for a particular breach, that will need to be clearly expressed. That's because liquidation excludes or limits the common law right to damages. Applying the Gilbert-Ash principle, there need to be clear words to do that. Now, this point is made in another of the authorities cited by the respondent. That authority is Chatham Developments and Rygill, which is at tab 13, page 179 of the authorities bundle. If we turn to page 20, paragraph 29, which is page 184, I'll ask your lordships to read this passage in a second, but for context, the court is dealing here with the same clause 24 in the JCT standard form as we've just seen in Temlock, save that this time there's been an oral modification which we needn't get into as we're focusing on the court's approach to Temlock. I can ask the court to read paragraphs 29 to 31.
Why does it have to be clear? I mean, it either excludes it on its true construction or it doesn't. Well, I mean, is it just that you don't expect people normally to exclude common law damages? But I mean, I'm just sort of understanding why we're looking for some clearer interpretation of the contract as opposed to just the normal one.
It's essentially an application of the Gilbert-Ash principle, my lord, in the sense that a liquidated damages clause would exclude a common law or limit or restrict a common law right to damages.
But if it does, it does. I'm not quite sure why we need to find. Is it just that it's not something you would normally expect people to do?
That, my lord,
I think that's what Lord Didlock said, didn't he, in Gilbert-Ash, that one needs clear words or something like that. If a party is to give up value, something like that.
If you construe it as having that effect, and you construe it, the point is that in deciding whether you will construe it like that, you would be looking for clear words.
Yes, I think as well.
My lord, paragraph 31 makes good my second point of the question of one of construction, but it also demonstrates this third point. A clear intention needs to be derived from the words of the contract. The court had been referred in that case to the Gilbert-Ash principle of paragraph 11 of the judgment. I say that clear intention is conveyed in clause 24 of the JCT form, on which my learned friend relies, by the features that I've already described. My fourth point is the crux of the matter for our purposes. Clause 8 is nothing like.
Okay, it is. Sorry, I should have reminded myself. Paragraph 11 is what I was trying to make, but just badly. Sorry.
It's a point also made in IBM and Société, which is in the authorities file, but I don't have the references to hand. My fourth point is the crux of the matter for our purposes. As I've said, clause 8 manifests no clear intention to liquidate damages flowing from the failure to make payment. I refer the court in this regard to the 3 points relied upon by the judge at paragraphs 160 to 162 of her judgment. They're at tab 9, page 122 of the call bundle. Given the time, I might just leave the court with that reference.
So, which paragraphs?
It's paragraphs 160 to 162, tab 9, page 122. My lords, we adopt the points made by the judge there, and I don't propose to paraphrase or repeat them. I had only a couple of comments.
Can I just ask you about the third of those, which the judge regards as very important at 162, which focuses on the first part of the clause, which requires payment of interest in the period before there's any failure to pay. Why does that count against the remainder of the clause, being the damages clause, where there has been a failure to pay?
My lord, because prior to the time of breach, the clause is clearly not liquidating any damages because there are no damages, because there has been no breach. Thereafter, there is a change in the sense there's been a breach, but there's no clear shift in the wording of the clause to indicate that its purpose has shifted from merely providing for a minimum payment to then liquidating damages. So we say you would need to see something clear changing within the clause between prior to breach and after breach in order for there to be a liquidation of damages. My lord, that was one of the comments I was going to add. The other is that there's no language of liquidation whatsoever in clause 8. And the third is the judge also made the point that clause 8 does not stand alone. I say that one can and should put that more forcefully. Whatever construction one adopts of clause 26, we will just discuss that with Mr. Drew. There's a prima facie conflict one would expect to see adverted to if this were a liquidated damages revision having the effect that the respondent contends for. My lords, those are the 4 headline points I wanted to make. In short, it's a question of construction. court needs to identify a clear intention to liquidate and thereby modify or replace the common law remedies, and no such clear intention is discernible in this agreement. 3 very brief points to sweep up. One, the respondent cites various penalty cases. I think it's now Lord's Vale and Bank of Zambia and Jean Chan that are in the bundle. They simply don't address this issue. Second sweeping up point, the eternal bliss is of no assistance. We refer to the judge's findings on that at 158 to 159 of the judgment. Third and final sweeping up point, even if the court were not with me on the submissions I've made so far, we say that Clause 8 could not liquidate damages for a deliberate breach of contract. Such the respondent's argument fails in any event. For context, my lords, the respondent's breach was presumed to be deliberate as a condition of the grant of permission to amend on this point. That's reference to paragraph 3 of our supplementary skeleton. The simple point is that even if one can somehow read into Clause 8 a liquidation of damages arising from a failure to make payment, it would require even clearer language to read in a liquidation of damages arising from a deliberate failure to make payment. We say the respondent gets nowhere near that. I refer your lordships to what we said in writing on that point at paragraph 11 of our supplementary skeleton. I've taken out a bit of a clip given time, but those are my submissions.
Thank you. Yes, Mr. Minister.
My lord, I will go through the grounds in turn. We can start with ground 1, just look at how it's articulated. It's in the core bundle, tab 1, page 15. It's described as the judge erred in finding that there was not a binding legal agreement in the joint report dated the 5th of September 2019 that Snowden would pay to Sahara the sum stated therein as undisputed. And the ground doesn't say that this is restricted to errors of law or fact. And I'll come to how it's actually framed in the skeleton. When we look at the judge's reasons for refusing permission, these are at tab 10 of the same bundle. And I want to emphasise them. If we look at page 138, tab 10, page 138, she says, ground 1, error in finding that the joint report was not a binding agreement in relation to undisputed sums, no real prospects of success. She says, not a pure question of law or construction, heavily dependent on facts, conclusions on which were informed by live, factual evidence heard. Claimant failed to establish agreement by some distance. The overall conclusion that there was a limited agreement on principal and contractual interest, but that in relation to undisputed sums there was no agreement. The joint report was no more than an agreement to agree is robust, supported by multiple strands, and I do not consider that there is more than a fanciful chance that the Court of Appeal would conclude otherwise. Obviously permission was given, but the point to stress is this is not a case where the appellant said at first instance that the judge was restricted to the words of the joint report. The appellant accepted and indeed asked the judge to look at what it termed as the legitimate context or the admissible context, but it made repeated and long submissions on the facts surrounding the meeting and the facts surrounding the relationship between the parties. And I think the court has also seen that in saying that the claimant's case or points on appeal are blending where it suits the claimant factual allegations, and when it doesn't suit the claimant, it is saying, well, we can only look at the words of the contract. But this is not a case where the claimant suggested that one cannot look outside the joint report, and this is a question of construction or purely a question of law. Just to give a flavour of that, if we look at the transcript for the closing on day 5, bear in mind the judge heard a large amount of evidence. If we look at the supplementary bundle, please, at tab 16. Tab 16, page 199.
So sorry, which page?
Page 199 of the bundle, and you'll see day 5 of the transcript, and I'm looking at page 41, starting at page 30, line 13. My learned friend says to the judge, so I would suggest that the reasonable objective construction, he's talking about the construction of footnote 4, which was a key barrier to the claimant's case as the judge saw it. So I would suggest that the reasonable objective construction is as I have set out in paragraph 34. Sahara will pay the reconciled claims within a reasonable time. They had been in Sahara's accounts, and the subject of Sahara's clause 8 position, and of course by definition they were what was payable under clause 8. Sahara will pay the undisputed claims, but will need time to arrange a schedule of payments. Sahara rejects the penal claims as being fair and agrees to go jointly with Sahara, seek to present arguments to the bank to try to persuade them to drop the charges. He then says, now I suggest that meaning is reinforced by the context. Now I've been very assiduous in trying to identify what is legitimate context from what is illegitimate context. At paragraph 35, I've tried to crystallize what we say is in indisputable relevant context. There had been a long outstanding issue which the parties have been trying to resolve. So how represented claims in 2017. There have been 3 previous meetings, the most recent in January. And he goes on, and this is summing up a long-standing submission on many facts on which the judge made findings. So this is not a case where there was a binary where the claimant was saying, well, no, you can't look outside the document. The claimant was actively relying on the factual evidence heard to make good its point, particularly on footnote 4. And we see that even in the skeleton before you. If we go to that skeleton of the core bundle at tab 3, page 38. So this is one of the 6 what are called essential criticisms of the judge's findings. Now item D is
which paragraph?
This is you see at page 38 item D. This is paragraph 43D. So if we go back a page, we'll see the gravamen of the first ground, which is essential criticisms, and then 5 are listed. You see that, my lord? And then if we go over the page, just taking an example, paragraph D is specifically saying that the judge didn't give adequate weight to the factual background outside the written document. The judge failed to mention, let alone consider and give effect to the admissible context of the parties' negotiations at the September meeting, namely 1, that general manager encouraged both parties to reach a quick resolution and so on. 2, that it was in the interest of both parties to reach a settlement of the claims, in that Sahara needed an agreement to pacify their by now fractious banks, and Sahara needed an agreement in order to obtain supplies of critically needed refined product from Sahara and so on. So the point I'm making is you have to take, this is a case where the claimant, both at first instance and before you, is saying that the judge got the facts wrong as well as the law.
Well, I'm afraid we have to proceed on the basis that Mr. Young saying something doesn't necessarily make it so. If the submission is that this is relevant factual material to the question of construction, but it isn't, it's not going to help you, is it, to say, well, these are all findings of fact and you can't go behind them. If they're not admissible, they're not admissible.
Of course, but neither side is suggesting that you have to remain within the 4 corners of the joint report.
As a matter of construction, that's never been the law.
Yes, and the danger is, and I'm going to give you some examples before I get into the detail, that if you start looking at the judge's judgment in silos and the evidence in silos, you get a misimpression of her logic and the care she took. Just taking one example. Now, the appellate judges, right, somewhat understandably, looked at one document and said, oh, this has got a seal on it, a stamp on it. And they asked the question, well, was this ever raised? And it was. So if we, for example, go to the transcript in the supplementary bundle at tab 13, I'm looking at page 90. Just bear with me. It's tab 13.1. I'm so sorry. So it's page 94.11. Are you there, my lord? It's 94.11. It's page 38 of the transcript. So if I'm looking at page 38, and if we look at from line 19, I took the Mrs Justice Cockerill to a document which is a meeting on the 31st of May 2017, and I say, we see the signature 325, Sonara stamp, and then a 326, everyone who attended signs. And then similarly, if we go to 351 for the business meeting on the 31st of January 2018, we see same sign with Sonara stamp, and then over the page, everyone signed. So we say that there is no particular significance of the document being signed. Just to put that in context, if we look at these documents, some of which happen to be in the bundle, if we look at the first one, which is at tab 7.3 in the supplementary bundle, page 49.14.
So can you just give me that reference again?
Tab 7.3 supplementary bundle. You see a business meeting on the 31st of January 2018. Do you see that, my lord? And then if we go to page 49.16, we see the stamp under the signature. If we go to tab 7.5, this is a letter from Mr. Njonu. He stamps it. 49.28, tab 7.5.
You're presumably asserting that nothing contractual was agreed at any of these meetings.
No, there wasn't. There was no case. I mean, there's no
Certainly
suggestion.
in relation to this dispute, but nothing contractual agreed at
No.
any of these meetings.
Not that I'm aware of. But even if we look at the letter, for example, 49.28, single page letter.
Surely what you've got to look up is what is the document upon which the signature and stamp are being placed.
Yes,
One minute. These documents do not purport to record an agreement, and they do not purport to record that something is undisputed. So we're construing this particular document to determine what does it mean when it says agreement, and as I understand it, the judge found, even if you didn't accept it at the trial, that it did contain a legally binding agreement. We then have to interpret what that agreement is, and we see that it records that certain things are undisputed, and we then see that your client's Director General has signed that and has put his stamp on it. Now, the purpose of signing and putting a stamp on is to show that you have approved the contents, which is what they do in relation to minutes, is in what they do in relation to letters. So the fact that there are stamps, the signatures are on other documents, doesn't mean there isn't significance in stamp and signatures being placed upon something which purports to record an agreement as to what is undisputed.
That may be the case, my lord, but the point I'm making is of the danger of this appellate court looking at documents and then making an observation. And I think the question was asked, well, was this something that was a lady that Mr. Justice Cockerill was addressed on? It was. And there is a danger. The only point I'm making is that there is a danger of this court.
Island hopping, but as I understand it, at the moment, what you're saying is that there's a danger. You're really addressing the question: well, are we here being invited to go behind the judge's factual findings? But at the end of the day, what the judge has done, as I understand it, is that she has looked at this and reached the agreement that this is a legally binding agreement.
I'll address you on what she has found is an agreement, obviously.
Are you saying she didn't find that this document contains legally binding terms?
She found that there was an agreement of items 1 and 2.
Legally binding agreement?
Yes. Whether it's not clear whether she said that is because it's recorded in the document or whether there was a meeting of minds between the parties. But she said the parties had agreed those items. And I'll take you to the document in due course. But there is a danger if this appellate court, who has been told that the judge has gone off the rails, in inverted commas, proceeds to rethink the vast amount of material that was before the judge in the course of an appellate hearing.
Well, we're alive to that danger.
The other example, I'm bearing in mind that you are alive to that danger, my lord. So it might be that I go through the issues, but it is important because the way that it is important to go through in some detail her findings on the background and then her logic in her judgment. It's not something that can be distilled into one paragraph or the other. So do bear with me. What I'll do then is I will go through her findings on the background and then her analysis of the joint report. And then finally, her ultimate finding, which is at tab 9 of the core bundle, paragraph 140. Page 117. That Sahara has not proven the balance of probabilities that an agreement was concluded as regards the undisputed claims. So if we start with her a lengthy judgment on the background. We see at tab 9, so we've got to start with the judgment, tab 9, page 88. She starts by setting out the 3 heads of claim, paragraph 3. We then go forward to page 98 of the bundle, starting at paragraph 30, where she says that between 2014 and early in 2019, there are 2 streams of relevant events. The first relates to Sahara's position vis-à-vis the banks. The second concerns numerous exchanges and meetings between the parties regarding absence of or delays to payment. So it's that second one that is relevant to the ground of appeal before you, because it goes to finding a fact that she made. If we start at paragraph 34 on the next page, she mentions a meeting in Dubai on the 12th to 13th February 2017. She says the first was a meeting in Dubai on the 12th to 13th of February 2017 between Sahara and Sahara to discuss various issues, including the 2013 crude supply. Sahara presented its claims. The outcome of the meeting is documented in a letter from Sahara dated the 20th of March 2017, which stated that Sahara rejected in block Sahara's claims. As to foreign exchange exposure, Sahara appeared to reject the claim because Sahara should respect the commercial contract governing each operation. As to penal charges, Sahara's position was that the claim was not justified. As to interest charges, Sahara did not appear to reject the claim outright, but stated parties shall proceed with interest reconciliation until a compromise is reached. She then says, paragraph 35, the minutes also made clear that the dispute was at that point proceeding on similar lines to those deployed before me, contractual interest versus clause 26, though this appears to be the first mention of clause 26. So she says that Sahara was saying, well, it was entitled to not just a contractual payment, but all charges. And Sahara responded, this is the second paragraph in the quote below 35, Sahara responded saying that interest claims are restricted to just contractual interest. She then mentions, paragraph 37, following a further meeting in May, there was another meeting relied on by the defendants of September 2017. And then, over the page, there's some dispute as to the, paragraph 38, there was some dispute as to the detailed calculation of contractual interest. Sahara reiterated reliance on clause 2016, or on clause 26. And then at paragraph 39, at this meeting, at a further meeting at the start of January 2018, Sahara's representatives disputed the incremental interest and forex elements of the claim. For example, the notes to the January 2018 meeting state, Sahara Legal expressed serious concerns on the extra charges not stated in the binding contract, like the forex differentials, and that Sahara cannot pay extra charges without a court judgment according to Cameroon law. The note went on to say that this figure represents Sahara's position for 2013 done on the basis of contractual interest rate. This position was, however, rejected by Sahara as not entirely representative of contractual terms and conditions. As she says, discussions continued in correspondence in 2018. We now get to 2019. The parties have been discussing the matter now for 2 years. And she says a further, this paragraph 41, a further reconciliation meeting was scheduled for January 2019. And then at paragraph 42, she says, however, early on it was noted that the points in the outstanding should be removed to a meeting when Sahara's general manager at the time, Mr. Maller, was able to be present. In discussion of the outstanding, Sahara clarified their position. Sahara Legal expressed serious concerns on the extra charges not stated in the binding contract, like forex differentials, and that Sahara cannot pay extra charges without a court judgment according to Cameroon law. And the Sahara, for its part, reiterated reliance on clause 26. She then talks about a letter in March 2019, which is, we don't need to go to it, but it's in the bundle at 7.4, supplementary bundle 7.4. In March 2019, against the background of continued correspondence, Sahara said, we have done a keen analysis of your claim and arrived at a conclusion that your claim on accruing penal interest and forex losses on the 2013 crude oil delivery transactions are not acceptable. Our decision is based on interpretation of our term commercial contract of 14th January 2013 on its Articles 8 payment and 26 events of default termination. Sahara responded that the delays and defaults were so extreme that they effectively rendered the terms of the contract null and void. And again, that letter is now signed, that 21st of March 2019 letter, which is in the bundle at 7.5, is actually signed by Mr. Njodu, who is now in position. So the position continues. There's a very firm position taken. There's the factual finding made. It's not disputed. There was a firm position taken for nearly 2.5 years now that these claims are just simply not contractually allowed, and Sahara is not going to pay them. She then continues that there is a submission made on a claim put forward on the 1st of May 2019 with substantial supporting documents. We then, if we go to page 104 of the judgment, so if we start with page 103, you see a headline, the September 2019 meeting. And if we go over the page, the judge mentions a letter sent on the 6th of August 2019. Sahara written to Sahara to bring to your attention the urgency of the prompt settlement of the outstanding amounts. It has become imperative that we receive a prompt settlement payment of the amounts with an official correspondence from Sahara advising the payment date and SWIFT. And then she says on the 28th of August, sorry, then she says, at paragraph 64, in mid-August, Sahara reverted, indicating a willingness to meet and an understanding of the position on principal and contractual interest, but reiterating its stance on penal interest and effects. If we can just look at this letter, because it's so close to the time of the meetings. This is at tab 7.7, my lord. Supplemental bundle 7.7. Page 49.32. So dated the 19th of August, 2019. And if we look at it's signed over the page by Mr. Najoni. If we go back to the page 49.30, it says, this is second from last paragraph. However, your summary of the financial outstanding is not the same as our summary, with reference to our correspondence dated the 21st of March 2019, which we advise that your claim on accruing penal interest and forex losses are not acceptable to us. Our decision is based on an interpretation of our term commercial contract of the 14th of January 2013 on its articles 8 and 26. In our books, therefore, while waiting for our next reconciliation session, the outstanding situation of Sahara Energy is as follows. And then over the page, it just refers to the principal outstanding and the contractual and late payment interest, which has now been paid and agreed. We are available for a reconciliation meeting, date and venue to be agreed to confirm final figures. As mentioned above, we are working on adequate solutions to solve the above long outstanding debt and its contractual interest. We seek your understanding and frank collaboration and hope to continue our valued business relationship with you. So this letter is sent 2 weeks before the meeting in September. It repeats a position now held for nearly 30 plus months, that the claims for incremental interest and forex losses are simply not contractually due. We then come to the judge's and this is part of the fact finding that the judge made, rightly. If we go to page 117 of the judgment, so that's tab 9, page 117. Paragraph 138, she says, this then dovetails with a further admissible background, including the position of the government of Cameroon. It is agreed that there had been a long-standing issue which the parties had been trying to resolve by now for years. There had been a number of reconciliation meetings in which Sahara had pressed for payment and where Sahara had made clear that they were not persuaded that the claims fell within the boundaries of their contractual liability. There is the unlikelihood of Sahara in the financial position it was in agreeing any liability that was not clearly established. So this is the factual acknowledgement that the judge makes in her judgment.
Sorry, what's fact finding about?
There had been a long
there had been a long-standing dispute in which Sahara pressed for payment and Sahara made clear that they weren't persuaded that they fell within the boundaries of the contract.
Yes.
That's a finding of what's happened up until this point of
yes.
time. Is there any other finding of fact which this court is not entitled to go behind in that paragraph?
Yes, there are a number of findings. Just bear with me.
In that paragraph.
Well, there is an inference from that there's an unlikelihood of Sahara in the financial position it was in agreeing any liability that was not clearly established.
That's the judge's inference from
yes.
From her findings of fact.
Based on all the evidence.
There has been a long-standing dispute.
Yes.
In which each side had maintained their position.
Yes, and there was also evidence before her that at the meetings, and I'll take you to the evidence from the transcript, no one talked about the contract. No one made a presentation on the meaning of Clause 8, Clause 26, and so on. So I'll take you those parts of the transcript.
Why is that admissible? As a matter of construction?
Well, if we are being asked...
What we've seen so far come within the category of evidence of negotiations. May not have been much meeting but it's classic, not relevant, or not admissible. Safe possibly that each side was maintaining its own position. What was discussed at the meeting, is that a way of negotiation, whether it was largely or wholly quantum, largely or wholly liability? Is that admissible as an aid to construction of the document?
Well, two things. Firstly, the respondent doesn't accept that this is solely a matter of construction. We say that the factual inquiry is whether or not there was a binding compromise of the claims for incremental interest and foreign exchange losses. And that requires you to look at the negotiations as a whole. That's our primary position. Obviously, if you're against me on that, then I say if it were purely a matter of construction, then it is common ground between the parties that there is at least an ambivalence in what is meant by further negotiations on the undisputed claims. I think my learned friend said that this morning. He said it's not very well drafted. So whether you look at it as a matter of looking at the negotiations as a whole, or whether you look at it as part of the factual matrix to deciding what this ambivalence means, you're entitled to look at it.
Are you saying, just so I can be clear, I mean, at page 4931, which is the letter you showed us,
Yes.
you said it sets out there the principal amount outstanding and the contractual and late payment interest. And it says, we are available for a reconciliation meeting date and ready to be agreed to confirm final figures. Well, the only figures they had there mentioned were principal and the contractual and late payment interest. I mean, are you saying, is it right court could look at this letter as part of the matrix against which the meeting took place, headed a reconciliation meeting, and as an aid to interpretation of the joint report? Is that permissible? Are you saying it's permissible, or is that actually something you rely upon?
Yes, I do. I mean, firstly, my primary position is that you are not in the task of construing the joint report, in the task of looking at the negotiations as a whole.
If you
were,
you say that would be okay.
Yes, because
that's what the parties thought they were turning up to do. You say.
No, it's not because of what they thought they were turning up to do. It was what was actually communicated. So that's an objective communication from one side to the other.
Let's turn up to the pub and have a drink. I mean, that's communicated to you. It's what we both think we're doing.
Yes,
They're
but
turning
also,
up to have a reconciliation meeting to confirm final figures that they've just set out. I think I may be trying to make a point in your favour, but I could be.
The point I'm making is that if it was a pure construction point, when we go to footnote, what I call footnote of resolution 4, which is at page 47 of the signed document, you are being asked, the court is being asked to read further negotiations on the undisputed claims to only mean further negotiations on the time for payment of the undisputed claims. And we say, at the very least, and I think this is common ground, this is ambivalent. So you have to look at the context. And the context will include the fact that it had been communicated for nearly 3 years.
I quite understand there's a very important distinction for the purposes of admissibility of evidence between, on the one hand, whether the parties have intended to conclude a binding agreement, and on the other hand, what that agreement means. But your submission, made twice now, is because there is some ambivalence about what is meant by the footnote referring to negotiations, that itself makes admissible evidence of what the parties have been saying before that. Now, I have some difficulty with that. However ambivalent it is, it's a matter of construction. Factual matrix is admissible as an aid to construction. What the parties intended things to mean, or what they said by way of negotiation, is not. If we're in the basket, in this case, of deciding whether these parties intended the joint report to reflect an agreement which was legally binding, then you can look at the bullet point about negotiation and decide what that means, but that's really construction. I mean, do you have a case on its not being legally binding that doesn't depend upon what's meant by negotiation?
Yes. Sorry, I'm just trying to understand. Do I have a case on whether or not there was
Suppose as a matter of
agreement.
construction, negotiation doesn't mean that undisputed means disputed. Is there anything else in the negotiations between the parties, the wider pool of evidence you say is admissible to whether there was a legally binding agreement?
Yes, there are a number of key.
Hold on, can I just finish the question? Which points to it not being intended to be legally binding, and if so, not being legally binding because it was subject to what?
So there are a number of things. Obviously, there's a text of the footnote itself, but in terms of the factual matrix, one of the key items is that it was accepted and was common ground between the parties, and I'll go to the transcript references, that Sahara itself would never be able to pay these figures. The government was the only party that could pay them. Now, my learned friend seeks to draw a distinction and says, well, actually, Sahara would be happy to sign up to liability because it didn't have to pay it. And I say that, but that's a nonsense. Sahara would need to check with the government if it was happy for Sahara to sign up to liability that the government would need to pay.
That applies equally to the contractual sums, the contractual principal and contractual interest.
Yes, but we've seen that the position has always been that the contractual interest is payable under the contract. That's the position consistently taken since 2017.
But is it your case that there was no legal binding agreement in relation to the principal sum and the contractual interest?
I haven't made a case on it, my lord, because obviously it's been paid, it's not in dispute. But the judge has found there was an agreement.
The judge has found it was,
but,
and there's no respondent's notice
no,
in relation
but
to that.
that doesn't necessarily follow that agreement was in this written document. It could have just been an agreement. It's just never been an issue. It could have been an oral agreement. It could have been agreement.
Yeah, I think paragraph 104 judgment. If you're going to maintain that, you're going to have to explain what you meant there. I would conclude that the parties reached a limited agreement only in the joint report. So she is saying there was an agreement in the joint report.
Yes, sorry, I'll have to accept that.
You don't challenge that, however.
No, I don't. And so then I have to accept that. There was another agreement, for example, at page 48, which is a swap agreement. It's actually called an agreement. But the fact that there is, and I think your lordships have this point, the fact that there is an agreement in this document doesn't necessarily follow that there is an agreement of the undisputed claims.
Right, but it does suggest that that's a question of the interpretation of the document, not whether the document was intended to have legal effect. I think that's the point we're on, which is why we're looking. I was trying to identify whether there was some other aspect of subjectivity, as it were, that you say no intention for this document to be legally binding, subject to.
I think I've lost the point on that.
Yeah, well, it's my fault. I'm not expressing
no,
it.
I've lost
I quite
the point of that
understand
first
you
instance.
say, if you look at this document, what it means in relation to the undisputed sums is they're to be subject to further negotiation, and that illustrates A, that they weren't agreed as undisputed, and B, that they were subject to further negotiation and therefore further agreement, and therefore there wasn't any binding legal agreement in relation to them. But that all turns upon the bullet point resolution.
Yes,
I'm
but
just trying to tease out
yeah.
is whether there's some other subjectivity. I mean, are you saying not legally binding because it was subject to approval by the government of Cameroon?
So when we're talking about legally binding, there's a difference between saying whether there was a legally binding agreement of some sort in this document. On that, the judge has already found that there was one, as your lordship has said. The question whether there's a legally binding agreement of the undisputed sums I say there are a number of points in that. It includes footnote 2, for example, page 47. Sonara will review and collect the documents for submission to the government of Cameroon. It includes footnote 4.
Sorry, when you say includes footnote 2, are you saying that is a subjectivity? In other words, that we get from that the parties did not intend to reach any concluded agreement, even if undisputed meant undisputed between them, unless and until the government of Cameroon said, yes, we will pay.
Yes.
So that's a separate, not intended to be legally binding yet, point.
Yes. But where I would go further is that I do say that even though there is a binding agreement in this written document for items 1 and 2, it doesn't follow that when you're looking at whether there is an agreement for item 3, undisputed, you are restricted to construing the document. You are able to still look at the negotiations.
I think I'd really like to know what you say about the law on that, because it seems to me that if you have a document which is described as an agreement and is signed by the parties, on the face of it, a legally binding agreement, there is authority, clear authorities, but it is possible to show that nonetheless there is no intention to create legal relations. It's not a binding agreement. Difficult in some circumstances, but it can be done. But if you have such a document which is found and now accepted to be a legally binding agreement, surely at that point the question is interpreting it, and the interpretation construction. Some of part of that interpretation may be that particular provisions are subject to conditions subsequent or precedent, or are not in fact creating a legal obligation but expressing an intention or whatever, or further negotiation is necessary, as you would say. But that's a different thing to the question of whether or not part of it doesn't intend to create legal relations. And what I wondered, is there some authority which suggests that that concept of not intending to create legal relations can be imported into just part of an agreement?
So I've looked for authority on this. I've not been able to find anything. There is a tension.
I'm surprised about that.
Possibly I've just not found it. But there is a tension between the test of whether or not the negotiations have resulted in an agreement, and if there has been an agreement on, let's say, items 1 or 2, whether your lordships are restricted to deciding agreement on item 3 based on that document alone, or you can still look at the overall negotiations. And in my submission, you should be entitled to look at everything, what the judge called the wider context. However, the judge was very clear that even on the narrow context, looking just at the document and what was agreed as admissible background, there was still not an agreement on the undisputed claims, and I'm going to look at that. But I would say, although I've not been able to find any authority for it, that where there are several claims being negotiated and only claims 1 and 2 are found to be agreed, while the court is then looking at whether item 3 has been agreed, it is allowed to look at all the negotiations, because otherwise you would be imprisoning a claim that may well not have been agreed.
Forgive me, I understand that, but what I have some difficulty with is that a reconciliation meeting, settlement meeting, whatever you call it, by definition, parties are going to give and take, or be invited to give and take. And so trying to compartmentalise documents. For example, there is no doubt that you did not agree the disputed items.
We rejected them, yes.
They were rejected, but you did agree, certainly, items 1 and 2. Why do we not have to look at item 3 as part of the party's overall agreement, which is reflected in the document? It's in the agreement. It's in the agreement. And as part of that agreement, why do we take it that they haven't, that element hasn't formed part of their settlement on give and take basis of the overall position? How can we treat it as a separate, how can we silo it and saying, well, that bit isn't part of the binding agreement?
Because of the, well, if for example you read the joint report and it was clear to you beyond doubt that this had been agreed, then obviously you'll be stuck with the joint report. The reason we're here today is there's common ground that one has to look at some of the outside facts because of the footnotes. There is nothing in the footnote that says the further negotiations are restricted to flexible payments, so on. That is a construction you're being asked to arrive at based on what the parties had discussed before.
Well, why Mr. Young put it was he says, well, look, you can look at this agreement and it's clear on its face, but insofar as one looks at the admissible contractual matrix, it supports that. That's what it says. I don't see anything wrong with that, and I'm not sure that means it's common ground that you're engaged in a free-for-all on what the subjective evidence is.
Okay, well, I'll then have to obviously answer that point that it's not clear on his face. But I think it is important to look at it. It may be that your lordships then tell me, well, none of this is admissible. But it is important in my submission, based on the evidence, because it goes to the background to that footnote, the communications about that footnote, to look at the first two drafts of the joint report. I take your point that if you find it's purely a matter of construction, then you will not be allowed to look at that. But if I may just look at those items with that proviso in mind. So we've looked at the long-standing position up to a couple of weeks before the meeting that these claims are not contractually due. She then turns to the meeting. Just bear with me. The first thing she notes is in paragraph 144, page 118. She says, so far as unnecessarily fragmentary recollections of the meeting was concerned, no one seemed to recall a debate on the clause 26 issue. And yet on Sahara's account, Sahara had during the course of the meeting either seen the light or at least ceded a long-held position. Now, you may take a view that it's not relevant what was discussed, but that is a factual finding she made. So to the extent it's relevant, the clause 26 issue was not debated. She then goes through the three drafts of the report and their material difference. So if we go to the judgment of paragraph 71, page 105. My lords, if I may trouble you to keep the judgment open and maybe pick up the supplementary bundle, is that possible? So supplementary bundle, tab 8. So this is the first draft that the judge mentions of paragraph 71, tab 8, page 50 of the supplementary bundle. And we'll see that it has a table 1, 2013 outstanding on principle. And at page 51, it has a single table, undisputed and reconciled. And that includes at page 51 the contractual interest. And then over the page includes the incremental interest and the FX differentials. And we'll see the comments that were suggested. I'll look at the difference between these and what was actually put in a moment. But the comments say that these figures were presented by Sahara, backed by supporting documents, and Sahara acknowledged receipt. After extensive deliberation, Sahara communicated her understanding of Sahara's position, which is to be paid the incremental interest amount in full. Parties would thereafter meet on a date to be agreed to discuss flexible payment terms to facilitate Sahara's payment of the incremental interest. I'm going to contrast this with the wording of footnote resolution 4 in the signed document, because obviously Sahara had here tried to make it very clear that the only further negotiations would be on flexible payment terms. And I'm going to distinguish this from what was actually then put in the document. The judge then at paragraph 75, we don't need to go to it, talks about the second draft that was produced by Ms Nassau, which appears at tab 9, page 56.
Sorry, can I just... Oh, thank you. You showed us the previous letter that I asked you a question about, which is just on the previous page, 4930.
Yes.
And 4930 contained numbers for the outstanding principal and the contractual and late interest, and said, we're available for a reconciliation meeting to confirm the final figures. Okay. And that's what you said was the background which led to the meeting on the 4th and 5th. Yeah. Yep.
Yes.
And on the document you've just given us at page 50, this is the day one first draft, yeah?
Mm-hmm.
The judge says it appears to be intended as a framework for discussion and agreement. And there's an agenda. Yep.
Yes.
And the first two dots are, as perhaps you might expect, given the previous letter that preceded it, the reconciliation of the outstanding principal and reconciliation of the contractual and late payment interest, yeah?
Yes.
But then somebody has recognised that there would be, or possibly, reconciliation, whatever that means, of the incremental interest, penal charges and forex differential, all of which were known to be disputed.
Yes.
So you then have the items 1 and 2 that you take us to, the outstanding on principle and the undisputed and reconciled as the heading. Yeah.
Yes.
And it does appear that the notes, the comments, say that those figures are all reconciled and agreed. Yeah.
Yes, these are comments from Sahara.
This is
This
a
is a
proposal,
draft.
essentially.
Yeah.
I mean, although it's in the form of a joint
Right.
report.
Yeah, this is their draft.
I get that. And but on that footing, there's no proposal for any further negotiations being suggested about those numbers, assuming that they were agreed.
Yes.
So how do you figure out when they're going to be paid or anything like that? I mean, what was the? I mean, this is the problem with going through sort of documents like this. I mean, what do we get from the points you just made to us about the difference that you identified
Well, the
between
point.
these, either between this document and the next one, or even between these points and the next point in this document?
Right. So
I'm struggling to understand the moment what.
yeah. So there's a
you
number
say
of
is
points.
critical.
So the first point is this is essentially Sahara's first draft. Yes.
Yeah.
So page 51 and
the
page
judge said at
52.
Paragraph 71. This is the first draft intended as a framework for discussion and agreement.
Yes. So at page 51 and page 52, the first point I emphasise is that the contractual interest and the incremental interest and forex losses are under the same category, and they're called undisputed and reconciled. They are not differentiated in any way. That's the first point I make. Second point I make is at page 52, in the comments that Sahara suggested, it was very clear that the parties would thereafter meet on a date to be agreed to discuss flexible payment terms to facilitate Sahara's payment of the incremental interest. This is very clear that the only discussions would be on flexible payment terms. And I say it is significant that the wording changes in the actual signed document, because the parties wanted, and Sahara insisted on, this was Ms. Nassau's evidence, insisted on everything is still up for grabs. So
Well,
that's
why did they leave the word undisputed?
the evidence from Ms. Nassau was that, well, obviously that was not accepted, that she understood that to mean only disputed with the banks. But her other evidence, which was at length, and I'll take you to, was that Sahara took comfort from Resolution 4. So they said, okay, well, we're not too fussed about undisputed as long as we have this Resolution 4 saying we can have further negotiation. So that's the first draft. And we'll see, obviously, that there is no footnotes because everything is in the comments table. We then have the second draft, which is Ms. Nassau's redlined document, which is at tab 9, page 56. And we see at page 57 the headline undisputed and reconciled. And then at page 58, obviously, there's a big change that the incremental interest and the FX differential are moved to disputed claims alongside the penal charges. And then we see the comments that she's redlined. After extensive deliberation, Sahara agreed to deliberate on the claim internally. Parties would thereafter meet on a date to be agreed to continue with the negotiations and possible flexible payment terms if an agreement is arrived at. And the same point is made on the...
It seems to me that if this is admissible, it's very telling against you, isn't it? Because here, during the course of negotiations, your clients had moved it into disputed and said they would want to deliberate and continue negotiations, but then after that, they agreed to them being moved back into undisputed.
Yes, but they kept that footnote, essentially, and this obviously this is a matter of construction, but the judge found that these comments appear in the footnotes effectively.
But isn't the move from a heading of disputed to undisputed undeniably highly significant if this is admissible?
Well,
why would a commercial party being taxed with liability for nearly $77 million agree to that being moved to a heading of undisputed from disputed if it's still disputed?
well, there's a number of things. The first is that Sahara also agreed to separate and divide these from the reconciled claims, and the people at the meeting saw that that created a difference. The second thing is that there were two very careful footnotes. We then look at the actual document, which is a page tab 7.
So page.
Page 45.
So where are we going now?
We're going to the signed doc, so that's the third draft, the third and signed draft, at page 45. If we hold this if we hold this, I'm sorry to make you do that, Melrose, but if we hold this against the judgment in the core bundle, paragraph 77 and 78, That's where the judge then begins to look at the signed document, the joint report. So she says in paragraph 77, following the meeting, those who attended the meeting on behalf of the parties signed the joint report. There's a further version of the same document plainly discussed between the parties as further developments were these. We look at the document, page 46 of the supplementary one. She says, item 2 became reconciled claims and the annotations were removed. Incremental interest in forest became a new item 3, undisputed claims with no annotations. Over the page, penal charges remain categorised as disputed claims. The middle annotation became Sahara communicated her understanding of Sahara's position and rejected the claims of the penal charges. And then she says, this is her judgment at 78, Roman 4, there were 4 resolutions whose genesis from the annotations is evident as follows. And then she sets out all 4 of them in full. And then she, if we go over the page, the bullet points after the section on the Bonnie cargo were followed by a further bullet point in bold. So if we look over the page at page 48, we see item 5, 700 kb Bonnie crude product swap agreement. And then we see the resolutions on that. And it says this agreement will be submitted to Sahara's banking and legal partners for validation. Immediately after this came the party signatures, and we see that at page 49. We then look at the actual analysis that the judge carried out. And my learned friend took you to part of this. If we go to page 114, in light of the documents. So just before I get there, and again I appreciate that your lordships may find that this is not admissible, but the judge then set out what happened after the meeting in case it was admissible in the wider analysis. And I just want to look at a couple of things there. It's page 108, paragraph 83. She talks about the internal report that Sahara produced on the meeting. And then she talks about 2 letters that I want to take you briefly to. Paragraph 85, she says on the 19th of September 2019, Sahara sent a letter to Sahara divided into 4 sections, which stated inter alia that we have sought a 2 months timeline for Sahara to revert with a firm payment schedule, disputed claims, stating Sahara's stance on disputing the penal charges associated with the 2013 long overdue financial outstandings as applied by the banks were jointly reiterated following the negotiation meeting, and 4 petroleum products supplied to Sahara and Cameroon. Section 1 on offset stated the financial reconciliation documents are signed by both parties, were submitted to Sahara's banking and legal partners in a bid to halt the severe ongoing legal actions. The banks have demanded an immediate offset on the financial balance on the Sahara crude and petroleum product swap deal dated the 26th of June. The offset has been applied against a portion of the agreed and reconciled claim, which are part of the long overdue outstandings to Sahara. Just bear with me one moment. just take you the letter itself? I would apologise for not going there straight away. It's tab 11 of the supplementary bundle at page 64. So if we look at this, this offset has been applied, the third paragraph under item 1. This offset has been applied against a portion of the agreed and reconciled claims, which are part of the long overdue financial outstandings to Sahara. So we see there in my submission that there is being a different portioning of what I call the agreed and reconciled claims from what I call the long overdue financial outstandings to Sahara. And then it says, the banks have stressed the importance for Sahara to immediately propose possible payment plans and commitments given the current situation of Sahara. The banks have requested that this is actioned within 2 weeks. However, after deliberations with the Ministry of Energy, we have informed the banks of Sahara's ongoing commendable actions to seek financial solutions and sought a 2-month timeline for Sahara to revert with a firm payment schedule with timelines and commitments. And then we see, as the judge mentions, at the next tab.
Sorry, is this inconsistent with Sahara's case as to what was agreed?
No, I'm not suggesting it's inconsistent. That they're asking.
They are treating
Well, it's not.
undisputed items as undisputed and payable.
Well,
My lord, this was to do with the counterclaim and resolving the counterclaim rather than the claim.
yeah, this is to do with the product swap.
Yeah.
My learner friend is right. But then we see at the next tab.
Is paragraph 2 is or not? Paragraph 2 of this letter was all the other long overdue financial outstandings.
So what they say is, if you look at the item just before, the amount of US dollar 24 million converted to euros at today's effective rates equates to euros 25,206. This will leave a balance amount euro 2071 and US dollars 4.9 still outstanding from the reconciled contractual and late payment interest portion as agreed and signed by both parties at the reconciliation meeting.
Yeah.
And I do submit that they're treating it separately.
That's item 1, as it were.
Yes.
That swaps in relation to how it's going to reduce item 1.
Yes.
And then paragraph 2 is everything else, isn't it?
Yes.
And that's treating it as long overdue financial outstandings.
Yes. But then we see the prompt. Well,
And paragraph 3 are the disputed claims.
yes. But then what we see is that on the 3rd of October 2019, which is the next document behind tab 11.1, Sahara responds saying, with reference to your letter dated the 19th of September 2019, regarding the above subject matter, wherein you are referring to our recently concluded financial reconciliation meetings on the 4th, 5th September 2019 in Limbe, Cameroon, in a bid to address pertinent and long overdue financial and legal issues with our banks, we kindly draw your attention to the fact that this meeting was inconclusive. And it was unanimously agreed that Sahara will communicate a date within 2 weeks from the 5th of September 2019 for another meeting in order to reconcile and finalise, and also for Sahara to propose potential flexible terms, schedule and further negotiations on the undisputed claims. That's, from my reading, a very careful cut and paste of the footnote. Sahara totally rejects all penal charges and requests for waiver of the same. Sahara will review and collate the documents for submission to the government of Cameroon. Documents concerning forex losses and incremental interest sent to Sahara will be reviewed, and we shall revert during the final reconciliation meeting. And this document, I submit, is relevant for 2 reasons. One, which may be less attractive to your lordships, is that on a wider view, we look at what happened after the meeting. And you may say, well, if you're looking at construction, we don't look at that. That's fine. But one of the, what was presented to you, that it should be taken as, I think it was the 6th item, that it should be taken as an agreed finding of fact, or an agreed fact, that Sahara was desperate for a deal to be concluded because it a required supply of product. And we say, A, there was no such finding, that is not a common position, but also it's if Sahara was so desperate, why would it be writing on the 3rd of October, saying straight away, well, no, we don't have a deal with you?
Where does it say that?
It says, we kindly draw your attention to the fact that this meeting was inconclusive and it was unanimously agreed, and then it sets out the...
So your interpretation of this is that Sahara was saying we haven't agreed anything. Is it?
that we haven't agreed the forex losses and the incremental interest, and that's why they say documents concerning forex losses and incremental interest sent to Sahara will be reviewed, and we shall revert during the final reconciliation meeting. Yes, so they're saying, no, we haven't agreed the incremental interest and the forex losses.
Well, are they saying they haven't agreed anything?
Seems inconclusive. I thought you were submitting that they were saying we haven't agreed anything. Which I can understand if your point was, look at them. The fact they're saying they haven't agreed anything, they can't have been desperate for a deal.
Yes.
But if all they're saying is we think our deal only goes so far, that doesn't really take us much further. That we've got letters after the event in which each side is reciting what turns out subsequently to be their case about what was and wasn't agreed.
I mean, if this case is all about contractual interpretation, this is a very good illustration of why you don't look at post-contractual documents to try and understand what was actually agreed.
Yes, but
if the case is actually about was there an agreement, i.e. an intention to contract, then you'd inevitably have to go sort of material to see what whether the parties had thought they had reached any form of consensus. The situation, as I understood it, is that you accept that there was an agreement, but it only went so far.
yes, I have to accept that because Her Ladyship has found that there was a written agreement for items 1 and 2.
But even if one's looking at this for purposes of seeing whether the parties thought they'd reached an agreement or not, one side's saying that they have and the other side saying that they haven't, that doesn't really inform the debate very much, does it?
No, but once the side that is seeking a finding of a compromise and payment under that compromise is saying to you that you should read into footnote 4 further negotiations on the undisputed claims only as to timing for payment. And what you're being told in order to read it that way is that the factual context was that on the 4th and 5th of September, Sahara was somehow desperate for a deal. And we said that's inconsistent with what's being said here. It certainly is not a factual finding that the judge made, and it's not something that was on the evidential record. When my learned friend talked about his item 6, he gave a reference that I wrote down, which was it was page 166 of the bundle, which is tab 15. So it's a supplementary bundle, I beg your pardon. Tab 15, page 166.
Yeah, I missed the reference, I'm sorry.
It's tab 15. This is the reference I took down because it was when my learned friend was speaking, so I think I've got the right one. He said, tab 15, page 166, transcript internal, pages 45 and 46. I don't find here anywhere where Ms. Nassau said that somehow on the 4th and 5th of September, Sahara was in such dire straits that it was willing to just sign a deal to get supply going. What I do have at page 5, at the next page, item 1, page 167, if we look at the transcript at page 52, line 13, the question is put, all right, well, you see, when you do a deal, a commercial deal, each party can state its legal position, but an ultimate deal can put those positions aside and say, well, let's just try and arrive at a satisfactory compromise. Would you agree? she said, as a public company, we don't have the right to preside the obligations, legal obligations.
If you take that to its limits, there couldn't have been any agreement on anything, including the swap in the joint report. I think everybody's agreed that there was, and the effect of the agreement on the swap was that the principal and late payment interest was largely swallowed up so that they didn't have to pay it. Let's see how that.
Yes, but
that was regarded as advantageous to Sahara.
Sahara had never.
As I understand it, was something that was agreed.
Sahara never suggested that contractually it wasn't required to pay contractual interest. That was never a sticking point. Sahara did consistently take a view that it was not contractually required to pay anything more than the contractual interest. And it was put to Ms. Nassau that, well, you just wanted to reach a commercial deal. She said, no, I wouldn't have put aside, as a public body, we would not have put aside our contractual rights to reach a commercial deal. But what the appellant is asking you to do is go a step further and say that it is part of the agreed factual matrix, that Sahara was somehow desperate for a deal to get its supply chain moving. That's simply not a factual finding.
Every time you enter into any contract, you are in a sense giving up some of your rights, giving up the rights not to act contrary to the contract. And the contract is by definition gaining rights and giving up rights, or taking on duties and giving. And a compromise agreement is just the same. So you can't get cancellation of or setting off of the contractual interest, the settlement, without that agreement. So I'm not sure what we're saying here. You're saying we can't consider any contract?
No, I'm not saying that, my lord. What I'm saying is, this is a point that goes to construction of footnote 4, resolution 4. So if we go back to that, which is at page 47 of the supplementary bundle, tab 7, page 47. So Sahara will communicate, sorry, I'll let you get them on. Says Sahara will communicate a date within 2 weeks for parties to reconvene. Sahara to propose potential flexible payment terms, schedule, and further negotiations on the undisputed claims. And the heart of Sahara's case is that further negotiations on the undisputed claims were unlimited. The parties were able to negotiate anything. And you're being told, well, no, you must read into that the further negotiations are limited to time for payment because Sahara would agree the liability because it was desperate for supply chain to move.
Well, I don't think it's put that high. I don't think they say that's the only reason.
Okay.
But that's why it means that. But I think we've got your point on.
But
on
in terms of
whether it's relevant at all, and whether there was in fact any finding that Sahara were desperate to do a deal. I quite understand you say there was no evidence that justified that, and there was no finding to that effect.
So, as a party that is seeking a payment of $76 million based on this document, Sahara needs to satisfy you on the balance of probabilities that when it says Sahara will communicate a date within 2 weeks for parties to reconvene, Sahara to propose potential flexible payment terms, schedule, and further negotiations on undisputed claims. This means something other than the plain wording that the parties discussed and deliberated and put in, which is further negotiations on the undisputed claims. Now, it's been suggested to you.
They're undisputed. That's what I think the argument against you is that the reason that's interpreted is because they are undisputed. How do you what do you negotiate in relation to something that's undisputed? You can't negotiate whether it's disputed because it's by definition undisputed.
I mean, I think your case, I've understood it, is you don't start, especially in the light of the history, with any presumption about what's meant by undisputed claims in terms of that label. It's just a label that's been put on those particular claims. And if you want to know about the extent to which they are or aren't disputed or what's to happen to them, you go to this footnote 4, as you've been calling it, and you find they're going to be subject to further negotiation, and therefore they clearly haven't been agreed. I mean, that's
Yes.
that may be a crude summary, but that's
Yes,
That's
I
your
mean,
case,
that is a point. That is a point that the judge saw as a primary point, which is that this footnote causes extreme difficulty for the construction that she was being asked to take. Now, a point being put to you was, well, the potential. Well, just a couple of points.
just before you move on to those. We've gone over by a little while. I don't want to stop you in mid-flow, but would that be a good moment for you to pause
Of course.
and come back tomorrow at 2 o'clock?
Thank you.
Okay, 2 o'clock tomorrow.
What, rise up the
And will you have a word with each other to make sure that you'll agree about when you're going to finish, Mr. Smith?
Yes.
Of course.
Of course.